Então, Tatiana, você pode ser Mrs. President dessa rodada, por favor? E aí, no seu comando, a gente inicia o controle de tempo dos oradores. Acho que está silenciada.
Excuse me, guys. So good evening, representatives of ANUR, representatives of Rango. It is a great pleasure to have you here before the International Court of Justice for this present case, questions relating to protected areas and armed conflicts. So along with me, I have Judges Marina and Judge Lucas, and it is a great pleasure that I announced the opening of this final session, calling upon the first agent for the applicant state to approach the bench and begin its submissions.
Good evening, Madam President, Your Excellencies. May it please the court. My name is Marina Nascimento, and I have the honor to appear on behalf of the federal states of ANUR, the applicant in today's proceedings. For the next 14 minutes, the applicant will proceed to address the first issue regarding the man-made wetland complex. My co-agent, Kimberly Oliveira, will address the second issue concerning the hotel development in the skilled coastal wetland for 14 minutes. With your permission, we respectfully reserve 2 minutes for rebuttal. Your Excellencies, over the course of the next 14 minutes, I will be submitting the following 3 points. Firstly, ANUR's actions at the MPFF's camp is consistent with customary international law regarding armed conflicts and complied with its obligations under treaties and conventions. Secondly, Rungo failed to submit an Article 3.2 report to inform the Ramsar Secretariat about the ecological change at the man-made wetland complex and thus violated international law. Thirdly, ANUR doesn't have to compensate Rungo for the damage caused in the man-made wetland complex. Beginning with the first topic, the applicant claims that it was exercising—
Sorry, Counsel. I noticed that you are not addressing questions of jurisdiction. Could you remember the basis of jurisdiction of this court for this case?
Yes, Your Excellency. The jurisdiction of the court is based on consent, and in this case, the consent was expressed by a unilateral declaration previously made by both ANUR and Rungo, recognizing the jurisdiction.
It was a unilateral declaration or a special agreement, Counsel?
Yes, Your Excellency, it was a special agreement. I'm sorry for my mistake.
Article 4.3 of that special agreement says that the parties, if they are unable to reach an agreement after this judgment, they can ask the court for another judgment. Don't you think that this violates the UN Charter, Council, and could even make this agreement invalid?
Can you repeat your question, please?
Article 4.3 of the special agreement that you made with the respondent says that if you do not reach an agreement after we render a judgment, another judgment can be requested for this court. Do you think that this is compatible with the system of execution of judgments established in the UN Charter? Aren't you violating the UN Charter and establishing that?
No, Your Excellency. The applicant claims that we are not violating the Charter. So immediately after the transmission of the judgment, the parties shall enter into negotiations on the modalities for its execution. If I may proceed, ANUR was victim to the launched attacks by the MPFF from the man-made wetland complex, which not only damaged 2 residential buildings, 1 government building, but also murdered several unruly citizens. Customary international law lays out the responsibilities of states and non-state armed groups during armed conflict. Therefore, the paramilitary group had the duty to distinguish between civilian objects and military objectives, where the attacks may only be directed at the latter. the rebel group also violated the 1949 Fourth Geneva Convention related to the protection of civilians in time of
Agent.
war. Yes, Your Excellency?
Excuse me, could you please clarify to this court whether can we actually come to the conclusion that the group per se is responsible for its action, or if we can maybe relate it to a state, particular to ANUR's actions?
Yes, Your Excellency. The applicant claims that the paramilitary group cannot be attached to another state. They were acting by their own, therefore they cannot be linked to any state, not ANUR or Rango. But still, since we're talking about a non-international armed conflict, they still have, as stated in the Geneva Convention, they still are bound by human rights to respond by their acts.
Agent, I do have a follow-up question on your answer. You just mentioned something regarding a non-intervention armed conflict, but wasn't this actually defined under the 1977 additional agreement to the 1949 Geneva Conventions, and therefore, if I'm not mistaken, aren't the parties not party of that agreement? Or did they accept it?
Your Excellency, both Rango and ANUR only are parties to the first Geneva Convention, and they did not sign to the additional protocols. So therefore, ANUR complied with its obligations under Article 51 and also used ad bellum, since the attack is legitimate, since the attack made by the MPFF parliamentary group was unlawful.
And can we find, Agent, a non-international armed conflict definition outside of the scope of the 1977 additional protocols?
Yes, Your Excellency, I believe the ICRC has a definition of that. Even the Inter-American Court of Human Rights, they have also a definition of that. So continuing, the parliamentary group had the duty to distinguish between civilian objects and military objectives, where the attacks may only be directed at the latter. Under the Rule 8, number 8 of the International Humanitarian Law, military objectives are objects which make an effective contribution to military action and whose partial or total destruction in the circumstances ruling at the time offers a definite military advantage.
I'm sorry, Consul, you were trying to convince us that you acted according to international law, but you didn't prove that you didn't violate the respondent's sovereignty by attacking the other state.
Yes, Your Excellency. The applicant claims that we did not violate Rango's sovereignty because under the law of interstate force, when a state conducts a targeted killing in the territory of another state, it does not violate the second state's sovereignty if the state targeting has a right under international law to use force in self-defense, because the second state—
Where is that based, Consul? This is not in the UN Charter.
Your Excellency, this paragraph is taken from the General Assembly, and we can also base the attack, the Article 51 of the UN Charter.
Which resolution of the General Assembly, Consul?
I'm sorry, Your Excellency, I don't think I have the name right now, but
yeah, but resolutions of General Assembly are not binding. Do you have any source of law that can offer legality to your conduct, Consul?
Yes, Your Excellency. Actually, I do have the number of the Assembly here. It's the A 1924 of the year 2005. And yes, they are not binding, but they can serve to guide this honorable court to make decisions. And also the Article 51 of the UN Charter.
Has this court, Consul, ever used General Assemblies to state the content of the law and international law?
Your Excellency, we also have Security Council resolutions that states that the Article 51 of the UN Charter can be used against non-state actors, and therefore the attack is protected under—
I'm not questioning the conduct against non-state actors, but the acts that you conducted in other states territory?
Yes, Your Excellency. So the answer is no, but it has already used report of the Human Rights Council, and we also brought a
I didn't
case
get you. The answer is no. You have no basis, so you violate
No,
international
Your
law.
Excellency. I'm sorry. I'm sorry for the mistake. Actually, no, we do not have a case of the ICJ that has used assembly from such as I mentioned. We do not have a case for that, but we do have a case where the ICJ has already used the report of the Human Rights Council, where the report also states that the respondent should have the duty to ensure, as far as possible, public order and safety regarding the MPFF attacks. So in this sense, UNHCR did not violate the Rongo's sovereignty.
You may proceed, please.
Thank you. UNHCR also complied with its obligations under the World Heritage Convention because Article 6 says that states should not take any deliberate measures which might damage directly or indirectly the cultural and natural heritage. This article, however, does not impose a strict liability, and therefore UNHCR complied with its article. Yes, Your
Excuse
Excellency?
me to interrupt you again, but can you clarify to this court if we could actually apply that into this case, considering that the site has not been considered yet to be on the list of the World Heritage as a World Heritage protected site?
Yes, Your Excellency. Article 2 of the World Heritage Convention states that wetlands should be considered a natural heritage. And since this article specifically says about the protection, conservation, presentation, and transmission of natural heritage, we are considering that these areas should actually be protected, since it's also a very important place to the international community as a whole. But we are stating that since the obligation was a fault-based standard supported in the arbitral award of Guinea-Bissau versus Senegal judgment of the ICJ, UNHCR did not violate this convention. So moving on to my next point, Rongo failed to submit the Article 3.0 report to inform the Ramsar Secretariat about the ecological change at the Manhit Wetland Complex. In this sense, the Article 3.2 is useful to notify if the ecological character of a Ramsar site has changed as the result of technological development, pollution, or other human interferences. And this notification must happen in the earliest time to proceed to be taken and the necessary done to preserve the area. Therefore, in 2014, when extended drought started due to climate change and adversely affected the ecological character of the Manhit Wetland Complex, the respondent had the obligation under this article to notify the Ramsar Secretariat, especially to develop actions to understand the changing and keep up with the situation. But until 2019, no actions were taken. It is important to emphasize that climate change, the attributed cause of the drought, is a consequence of human interferences. And even if it is not traceable, meeting the demands of Article 3.2. So when UNHCR made the attack, it had no knowledge about the drought situation and given the characteristics of the Ramsar site, led to the drastic situation of the fire. It is very important to emphasize that the destruction was. It is very important to emphasize that the commander from UNHCR conducted a proportionality analysis and determined that destruction was not excessive to the concrete and direct military advantage, since the drought situation could not be pondered because Rongo did not inform about the situation, even though they had obligation under international law.
I'm sorry, Counsel, to interrupt you. You are arguing that the attack had no effect at all. It was only caused by climate change.
No, Your Excellency. Actually, the applicant submits that the drought the drought is the reason why the damage escalated so much. Because since the commander of UNHCR made a proportionality analysis and had no knowledge about the drought situation, nothing could be done to actually analyze the situation as it was. That's what the applicant submits. So if I may move on to my last topic.
Perhaps in your first 27 seconds, you could summarize your claim, Counsel.
Yes, actually, UNHUR doesn't have to compensate Rongo for the damage caused in the manmade wetland complex. Firstly, because of Article 2 of the United Nations on International Wrongful Acts states that there is a breach of international obligation by a state when an act of that state is not in conformity with what is required by that obligation, regardless of its origin or character. If I can be of no further assistance to the court, this would conclude my submission. Thank you, Your Excellencies.
Thank you very much, Agent. Now we call upon the second agent to take the stand.
Good evening, Madam President, Your Excellencies. My name is Kimberly Oliveira, and as stated by my co-agent, I will be guiding this honorable court through the second issue of whether the actions of Rongo with respect to the proposed hotel development violate international law.
I'm sorry, Counsel. You introduced yourself as agent. I'm calling your colleague counsel. What is the difference between a agent and a counsel before the International Court of Justice? And how should I call you?
Your Excellency, I apologize for my mistake. You may call me counsel as well. An agent is a representative of the state, but in this case here, we are acting as the lawyer, not only representing the state in a proceeding such as advisory opinions. If I may, I will be over the next 14 minutes submitting the following 3 points. Firstly, that the skewed coastal wetland is a Ramsar site and therefore protected under international law. Secondly, that the site is also under the protection of other international instruments, which are binding upon the state of Rongo. And thirdly, that the economic rights of the local population cannot suppress the rights of the environment. Beginning with my first topic, the applicant claims that the construction of the proposed hotel development constitutes a violation of international law as it demonstrates the respondent's failure to perform its positive obligations arising from a global environmental concern. Article 3.1 of the Ramsar Convention expressly determines that states parties must promote the conservation of the wetlands included in the list. Moreover, Article 4 of the same convention specifies that the promotion of the conservation shall be done through the establishment of nature reserves on wetlands. As per Resolution 11.9, not only should states prevent negative impacts, but also mitigate unavoidable impacts and compensate or offset any remaining impact. In this sense, yes, sir.
Excuse me. I do have a question concerning the environmental impact assessment that was carried out. Can you clarify to this court the relevance of that environmental impact assessment and the fact that it said that although it was made in accordance to domestic legislation, it was likely to interfere with the royal riley nesting habitat? Could you address that issue?
Yes, Your Excellency. Rongo's Ministry of Environmental and Development and Sustainable Development granted the building permit after the environmental impact assessment was done in accordance with the respondent state's legislation. However, the applicant submits that the question of Camp Key sovereignty is not yet decided. And in this sense, not only should Rongo do this impact assessment according to its own legislation, but he should have consulted the applicant. Moreover, in accordance with the Convention on Environmental Impact Assessment.
Just a quick question, Agent. If it hadn't consult or if it doesn't consult, what is the opinion of this court on that?
Your Excellency, the court has, in the case of pulp mills between Uruguay and Argentina, has come to the conclusion that it is for each state to determine in its domestic legislation or in the authorization process the specific content of the environmental impact assessment required in each case, having regard to the nature and magnitude of the proposed development. And in this sense, the applicant claims that the respondent state had a duty to notify, seeing that the applicant will also be impacted from the negative impact that will not be mitigated by the respondent state. Moreover, Excellency, seeing that there was no change in the status of the skewed coastal wetland as a Ramsar site, seeing that neither UNHUR or Rongo requested the delisting nor submitted any notification to the Secretariat requesting the deletion of the site from that list, as prescribed by Article 2.5, dispute coastal wetland must still be considered a Ramsar site. Moreover, in addition, the Vienna Convention on the Law of Treaties of 1969 notes that the principles of good faith and pacta sunt servanda rule are universally recognized. And in this sense, by being a signatory to both the Vienna and the Ramsar Conventions, Rongo must comply with its obligations in good faith, carrying out its liabilities and duties. Now, if I may move on to my second point, the biodiversity.
Hi, Agent, sorry. Can I ask you a question on the Ramsar Convention? Does the Ramsar Convention always stands for sustainable tourism, and would it be an issue to point out Ramsar Convention non-compliance based on tourist sustainability of the proposed activity in the site?
Your Excellency, the Ramsar resolution, if I'm not mistaken, 11.7 allows for sustainable tourism in the area. However, what we as applicant are submitting is that the state has not presented any form of mitigation of the impact. Resolution 2.3 expressly determines that when the transformation of the wetland is planned, it is the state's duty to provide measures to mitigate, exclude, or compensate any adverse effects of wetland transformation. In this sense, the respondent state has presented one mitigation measure, which is the installation of window tinting or shade screens on glasses and windows that would face the beach. But this is in relation only for the marine turtles that have their nesting habitat in the area of the proposed marina. Moreover,
yes,
they
Council,
have not.
You invoked the word sustainable under the notion of sustainable development. Introduces also the social dimension and the needs of the state to develop its economy. Why do you think that they are not taking that into account in the notion of sustainable?
Your Excellency, what we defend as applicant is that the state of Rongo should apply the no net loss strategy, which is a goal for a development project, policy, plan, or any activity in which the impacts of that will cause on biodiversity are balanced or outweighed by measures taken to avoid and minimize the impacts. Moreover, such measures as the restorance of affected areas, and finally, the offsetting of any residual impact so that no loss remains. In this sense, although the applicant claims to have done the environmental impact assessment, the only mitigation measure presented before this court is in relation, as I mentioned before, to the sea turtle population. No mitigation measures was presented in relation to the wetland area in itself. There was no proposition.
But you are basing your argument, Council, in a resolution of the Ramsar Convention and the Ramsar Conference of the Parties. What legal value we should attribute to that?
Your Excellency, we affirm that the resolution is binding upon the state. However, they do not have a mechanism to enforce it. Moreover, according to the Institute for Water Education,
where in the Ramsar Convention does it say that the resolutions are binding?
In Article 6.2 of the Ramsar Convention, it stated that the conference of contracting parties shall be competent to adopt recommendations or resolutions. Moreover, in its Article 7.2,
recommendations are not binding, to my knowledge, Council.
As I was mentioning, Your Excellency, Article 7.2 states that these resolutions and recommendations will be voted at the conference and adopted through the majority. In this sense, seeing that the states participated in these conferences and they voted for these resolutions, they are binding upon the state of Rongo.
Yes, Council, but do you have any piece of jurisprudence of this court that consubstantiates your claim, Council? Because I'm not convinced that these articles that you mentioned make these resolutions binding, only recommendations, which is what they are.
Your Excellency, I am not able to provide this answer at this time. I'm not sure if this court has pronounced itself already on this issue. However, we do have other instruments of international law which are binding upon the state of Rongo, such as the CBD and the IAC, and they were also
that the CBD can be invoked before this court, Council?
Yes, Your Excellency, both states parties are are signatories to that convention, and this court may.
But there is a dispute about the CBD. It was invoked in your agreement as applicable law to this case.
Your Excellency, what we submit is that Rongo is a signatory. Even if he disagrees in this specific agreement, he is still a part of that convention, and he cannot invoke national law in order to not oblige to the agreements he undertook when acceding to the convention. Moreover, Excellency, if I may move on to my third point, the economic rights of the social population should not prevail over the rights of the environment. And in this sense, we like to present this court with the cases of the African Court of Human and People's Rights, in which it decided in social and economic rights.
I'm sorry, Counsel. Before you invoke the jurisprudence of a court that is not our court, let me ask you this. Your co-agent or co-counsel assumed a very restrictive approach to the protection of the environment. You are using the protection of environment as your horse battle. Do you think that your approach is consistent? You were so worried about the environment when you bombarded the territory of the other state.
Your Excellency, I understand your concern, but what we submit is that Rongo did not take the appropriate course of action, seeing that UNHUR did analysis of the proposed damage that would be caused to the Manhid wetland complex in accordance with information it had available at that time. However, Rongo, when planning this proposed construction on this cute coastal wetland, did not take into account the environment, seeing that they are still not proposing any mitigation plans. And in this sense, UNHUR did not violate international law.
Counsel, but they conducted they did all what they could to perform that obligation. Do you have any piece of evidence or any piece of law that imposes obligations in this regard, any principle, if you want, that imposes a certain conduct from Rongo?
Yes, Your Excellency, as I mentioned before, the convention, if I may move back to my aforementioned point, there is a convention on, I'm sorry, I just lost my information, but there is an obligation on the states to inform the other state that will be impacted by transboundary harm. Moreover, Excellencies, Rongo is still not declared as having sovereignty over Camp Key, and in this sense, he could not dispose of the wealth and the resources. He could await until there is final decisions on the point of sovereignty. Moreover, Your Excellency,
Counsel, what kind of transboundary harm do you mention when you speak that there is a transboundary harm in this case?
I thank you for your question, Your Excellency. The Royal Wiley sea turtle has 35% of its nesting habitat in the cute coastal wetland, but as a migratory species, not only the turtle, but also other migratory species will be impacted. And in this sense, UNHUR is also concerned that not only will there be harm done by Rongo if the state of UNHUR is declared to have sovereignty over the Camp Key. In this sense, there would be a transboundary harm as the respondent state, which does not have, as of now, sovereignty, would be causing harm in another state's territory. And
I'm sorry, Counsel. Could you please address then the question of the referendum, where more than 90% of the population recognized that? What weight you attributed to that in your last 30 seconds?
Your Excellency, I appreciate your question. We do understand that there was this referendum, but we do not know the conditions in which it was made. However, we still are still debating this question in other fora, and therefore there is still no judicial this settlement was not yet decided in the international context. And if I can be of no further assistance to this court, I shall rest my case.
Thank you very much, Agent. Now we call upon the respondent, the first agent for the respondent. You can approach the bench and begin your oral argumentations.
Thank you, Madam President. Good evening, Madam President, Your Excellencies. May it please the Honorable Court, my name is Gabriela Bellotti, and also on the panel is my co-agent, Carolina de Caldas Bezerra. We appeal on behalf of the respondent in the present matter, the Republic of Rongo. I will address this court for 15 minutes on the question whether Rongo violated international environmental law with respect to the hotel complex project, as well as why UNHWR violated Rongo's sovereignty with its armed attack on the Menhir wetland complex. My co-agent will be furthering my submissions regarding the violation of international environmental and humanitarian law by UNHWR's attack on the Menhir wetland. My speech will specifically address that first. Rongo did not violate the Inter-American Sea Turtle Convention, nor the Convention on Biological Diversity. Second, that Rongo complied with the principle of sustainable development. And finally, that UNHWR violated Rongo's sovereignty. Your Excellencies, to contextualize my submissions, if we may look at paragraph 35 of the record.
Before you start and we find paragraph 35, I will ask you the same question and ask it to the applicant, since it is a special agreement that bases the jurisdiction of the court. Article 4.3 says that if the parties are unable to reach an agreement after 6 months, you can ask the court to render an additional judgment. Do you think that this violates the system of sanctions established under the UN Charter to the judgments of this court?
Your Excellency, the respondent submits that a second judgment would not violate the UN Charter if the first decision was annulled and not considered. Now, to contextualize.
Do you have any piece of practice of this court in which the court separates the judgment on merits and on reparations counsel?
Yes, Your Excellency, in the Democratic Republic of Congo versus Uganda, which was recently, the reparations portion of the judgment was recently judged. The merits were judged in previously, and
Thank you, Counsel. You may
reparations.
proceed with your claim.
Thank you, Your Excellency. So in paragraph 13 of the record, it is stated that the Rongoan Ministry of Environment and Sustainable Development announced that it was granting a permit to the construction of the hotel complex within the skewed coastal wetland with the objective to increase ecotourism in the area, as well as promoting the development of the local community. Now, we highlight that an environmental impact assessment was indeed conducted prior to the announcement, and observations were made in the permit as to only allow the construction if measures were taken to block internal lights that may interfere with the Royal Ridley's nesting habitat. That said, the project perfectly complies with the Inter-American Convention for the Protection and Conservation of Sea Turtles. Now, this convention has never prohibited human activities in the nesting areas of animals, but rather institute that measures must be taken around those areas to conserve, recover, and protect the sea. Yes.
Excuse me. When we are talking about an environmental impact assessment, are we talking about a conduct of means or a conduct of end in terms of protecting turtles, or only carrying out the environmental impact assessment in order to construct?
Your Excellencies, it is a conduct of end once the main purpose of conducting an impact assessment is to further protect biodiversity, as stated in CBD's Article 14, that provides guidelines for impact assessment in minimizing adverse impacts.
Do you think by any chance that this prescription contradicts this court's findings in various previous judgments concerning the environmental impact assessment carried out by various states in their projects?
No, Your Excellencies. In fact, in the Pulp Mills case, the judgment was that in cases in which are likely to cause adverse impacts on the environment, an EIA must be conducted, and that was recognized as customary international law in that case. So,
I'm sorry, Counsel, let me add a question in relation to that. Do you intend to answer the applicant's accusation that you have no mitigations measures in this regard? So you are in violation of international law, or this is not planned to answer?
We are planning to answer that. In fact, we are applying mitigation measures with the shading, applying shading and tinted windows or special fixtures onto the screens that onto the windows that protect the direct flow of light into the beach. In fact, according to the Sea Turtle Conservancy, an international nonprofit organization based on scientific evidence, a pervasive challenge throughout the Caribbean region where Rongo and Anhur are located is light pollution at the beachfront. But fortunately, reducing light pollution is among the most manageable conservation practices.
I'm
Now,
sorry,
artificial-
Council. Have ever this court relied on ONG as evidence?
Your Excellencies, I will not be able to give you any specific answer right now. However, the ICRC, the International Committee for the Red Cross, can be considered an NGO, and it has a special mandate on humanitarian law, and it has been considered in this court. Now, artificial lighting per se does not need to be eliminated if proper light management techniques are adopted. Now, artificial light only becomes a problem if the light or glow from the source can be seen from the beach during nesting and hatching seasons. Hotel and resort projects in their initial stages of development are encouraged to incorporate good lighting techniques into their building plans as the responded EIA submits. Now, the best practice is to prohibit lights near the nesting beach area and adopt sea turtle friendly lighting like low pressure sodium lights that have longest wavelengths, which sea turtles do not detect as readily. Now, Rongo is,
I'm sorry,
as said,
Council. You're
yes.
saying that your measures involve only the protection of light, but do you think that you consider the fact that 304 bedrooms would have no effect at all in to these turtles and to the environment? Don't you think that 304 guests together using all the beach and the rooms of the hotel wouldn't have any impact? Do you think that only the light is the problem here? I'm correct that is your claim?
Your Excellency, any act done by humans is bound to have an effect in the environment. Now, it is our job to mitigate this impact. So in our case, to show that we are committed to applying mitigation measures. In fact, we are only going to build this hotel after this matter is settled before this court. Now, in the future, if anything else comes up in the EIA, which still hasn't come up, I am sure that the respondent will comply with all its mitigation measures needed.
Council, in
Yes.
environmental law, you have always seek to try to do everything previously as the damage that is caused. So if you're saying that you are going to take measures if something happens, you're saying that the environmental impact assessment is not clear on all the impacts that the hotel is going to cause in the environment. Am I correct?
Respectfully, no, Your Excellency. The respondent submits that the EIA is a preliminary stage of the building of a project. We are not saying that if anything comes up after the project, we will apply mitigation measures. We are saying that in between the settlement of this matter and the start of the project, after more studies are conducted, we cannot construct this project based solely on the IEIA. There certainly will be more studies to be conducted. However, in the record right now, the EIA and the lighting situation is the only likely effect to the sea turtle population that we have. That said, Your Excellencies.
And do you believe, Council, that these two questions and these two measures are enough to fulfill the requirements of the precautionary principle and the prevention principle?
Your Excellencies, the applicant submits, the respondent submits that those two at this point in time are sufficient and are in compliance with the principle of prevention and the precautionary principle. Now, the hotel complex also complies with the principle of sustainable development, one of the core principles of international environmental law. In fact, with it in mind, the Rongoan Ministry of Environment and Sustainable Development allowed the construction of the hotel as a way to increase
Where is this principle defined, Council?
Your Excellency, this principle is defined in the Principle 5 of the Johannesburg Declaration, and where it's assumed a collective responsibility to advance and strengthen the interdependent and mutually reinforcing pillars of sustainable development, namely economic development, social development.
Sorry, Council, for interrupting you, but the Johannesburg Declaration is a non-binding, it's a declaration. Do you have any piece of law to convince this court?
Your Excellencies, in the Article 11 of the CBD, it establishes that states shall adopt economically and socially sound measures that act as incentives for the conservation and sustainable uses of biological diversity. Now, even though it is not explicitly said, the term sustainable development, given the Johannesburg Declaration meaning, as well as the other principles from Johannesburg and Rio Declaration, we can see the principle of sustainable development reflected in this Article 11 of the CBD.
Has the court jurisdiction to make any pronouncements on the CBD?
Yes, Your Excellency, according to Article 38 of the ICJ statute, it is, I apologize, it's not Article 38. It's Article 28. I apologize. I do not know the name of the article exactly, but it's the Article 36 that talks about jurisdiction. And the states shall present matters to the court to declare either their judgment on an interpretation of a treaty, any question of international law. Therefore, the court has jurisdiction to interpret the CBD. That said, Your Excellencies, those rules, Article 11 of the CBD, and also the IAC, with environmental protection of the forefront, allow member states to increase ecotourism, which, for context, is a form of tourism involving responsible travel to natural areas, conservation of the environment, and improvement of the well-being of the local people. Now, regarding the latter, the IAC establishes that it's Article 2 that it is necessary to take into account the socioeconomic characteristics of the state in discussion, and that is so that middle-income developing countries such as Rongo have room for development both economically and socially. This is actually supported by the preamble of the CBD that recognizes that economic and social development, as well as poverty eradication, are the first and overriding priorities of developing countries. Consequently,
sorry, Council, is the preamble of a treaty binding?
No, in fact, it is not binding. However, according to Article 31 of the Vienna Convention on the Law of Treaties, preambles are relied upon to provide interpretation of the treaty, to provide the purposes of the treaty, and meaning that the provisions in the treaty, the actual articles, should be read into that context of the preamble. Now, consequently, the construction of this hotel will bring both economic and social benefits, not only to Rongo as a middle-income developing nation, but mostly to the local community. Further,
Council, I'm sorry. Are you addressing the matter that the non-compliance with Ramsar conventions in this case that was brought by UNHUR?
Yes, Your Excellency. In fact, the claim by UNHUR is that the respondent violated Article 3.1 of the Ramsar Convention that states that contracting parties shall formulate and implement their planning so as to far as possible to promote the conservation of the wetlands on this list. However, this provision of the Ramsar Convention is quite vague when it says as far as possible. So in the respondent submits that in its shoes as a middle-income developing country, in considering the sustainable principle, sustainable development, and balance between economic development and environmental protection, it is complying with this article that in its text does not prohibit any activities involving wetlands, but does institute mitigation. Your Excellencies, I see that my time is up. May I have just 30 seconds to finish my submissions or less?
You have a sentence, Agent.
Perfect. Your Excellencies, for the topic on the violation of sovereignty by UNHUR, I refer you to our written memorials. Now, that said, Rongo's sovereignty was only one of the many violations of international law by UNHUR, as my co-agent will now demonstrate. I thank the court for its indulgence and may it please the honorable court.
Thank you, Agent. Now we call upon the second agent for the respondent.
Madam President, could we wait for a second while the timer is being updated, because it's just a little bug here. No, absolutely. Agent, you may now proceed.
Thank you. Are Your Excellencies hear me well? Yes, thank you. Madam President, Your Excellencies, may please the court. My name is Caroline de Caldas Bezerra, representing the respondent, Republic of Rongo. I will speak for 15 minutes regarding the following. First, UNHUR violated international humanitarian law as the Manhill wetland complex was not a legitimate military target. Second, UNHUR failed its duty to cooperate towards environmental protection. Third, and finally, UNHUR must compensate Rongo. Your Excellencies, my first submission will state a violation of international humanitarian law, since the case at hand is consistent with its application. During armed conflict, the international humanitarian law also seeks to conserve the natural environment, which is essential to human life. Additionally, the Manhill wetland complex did not characterize a military objective. According to the International Committee of Red Cross, the environment is covered by general provisions regarding warfare. Unless it has been developed into a military objective, the environment is civilian in character and cannot be attacked, as it indicated in the principle of distinction to the natural environment, outlined by the guidelines on the protection of the environment in times of armed conflict.
Counsel, oh, sorry. Go ahead, President. Go ahead, President.
Now, I was just wondering, why should we take into consideration that document that you just quoted? In terms of its sources of international law?
Sure. This document was promoted by the International Committee of Red Cross, which is an internationally recognized NGO in the international law studies. And also the principles that I quoted is considered as customary international law. And it was stated in diplomatic note by Rongo that it's considered as customary law. In that sense, military targets are defined by Rule 8 of International Humanitarian Law as objects that by nature, location, purpose, or use make an effective contribution to military action, and whose total or partial destruction, capture, or neutralization offers a definitive military advantage. Thus, as the Manhill wetland
wasn't that exactly the declaration made by the military in charge of the operation in the north when there was this attack, or to take that into consideration? Considering, please.
You can finish your question.
No, I was wondering because if I'm not mistaken, there was a declaration that says on the clarifications that actually they serve their purpose, duly proportional analysis, wasn't it?
Your Honor, you are correct. UNHUR did a proportionality analysis. However, as it is stated by UNHUR in the record, UNHUR did not consider the environment as civilian in character. And as stated in the clarifications, the commander stated that the harm that would cause the environment would not harm civilian objects, civilian or other provisions. And by circumstantial evidence, we can affirm that UNHUR did not take the environment as consideration and is not considered a military objective.
Is there any impact, Agent, on the fact that the declaration said it was not excessive? Do we need to have, we cannot attack civilians in times of conflict, or when attacking, we should consider the damage they may cause. And then when we balance those actions, therefore, we take that into consideration. And if they're not excessive, it is okay.
Your Honor, first, the international humanitarian law seeks to protect civilians in times of armed conflict if they are not participating or no longer participating in the conflict, and it should have been protected. But for your second point of the question, if the environment was a military objective, the damages that would occur would be no excessive, and the court would have taken this in consideration. But in that case, this the wetland is civilian in character, therefore it must be protected and had no damages to that area. Your Excellency, it is very clear that by attacking the Manhi wetlands, UNHUR has violated international humanitarian law. The violations are twofold. Firstly, in regard to the lack of military legitimacy and proportionality of the attack. And secondly, in relation to UNHUR's duty as a member of the Ramsar Convention to protect all wetlands. In that sense, the ICJ has already expressed an opinion on the legality of the threat and use of nuclear weapons, and I quote, "States must take environmental considerations into account when assessing what is necessary and proportionate in the pursuit of legitimate military objectives. Respect for the environment is one of the elements that go into assessing whether an action is in conformity with the principles of necessity and proportionality."
Sorry, Counsel, but the applicant said that he made this test and he was not aware of all the information available to him because of the not updating of the Ramsar Convention and the situation of the wetland. Don't you feel that you have some guilty, that you have some, let me say, not clean hands to make this allegation?
Your Honor, we cannot take fully into consideration a proportionality analysis because we don't know the specific points that were considered in the study. And however, moreover, that UNHUR should have taken into consideration the natural characteristics of the area. It is known that some areas are facing natural droughts because of global climate change. It is not something that is happening exclusively in Rongo site. And specifically, the attack was on 6 November 2020. And this is the specific place that the phenomenon of El Nino occurs. The phenomenon of El Nino makes the swamps areas very dry. Therefore, the proportionality analysis must take into consideration all the natural characteristics of the environment. And that's why the fire propagated, because the proportionality analysis wasn't fully conducted. In that sense, a plea of necessity does not cover conduct regulated by a primary rule. Article 2.4 of the Charter, in that case, it follows, therefore, that it does not cover an accession of military necessity that is subject to regulation.
I'm sorry, Counsel. I like your El Nino argument, but don't you think that it helps the applicant? Because at the end of the day, it was not his fault. It was not its fault for the applicant, and the El Nino should make you to update your information about your wetland, so he would be aware in order to conduct a proper proportionality and necessity test, no?
No, Your Honor. Article 3.2 from the Ramsar Convention states that states has the responsibility to communicate changes if the wetland is changed, was changed or is likely to change due to technology development or human interference. And the El Nino, it's a natural phenomenon. It is not human interference, it's neither technology development. And these natural characteristics of drought in the swamps area are really known. And UNHUR should have taken that into account when firing a major drone attack that burned 65% of the swamp area, destroying 85,000 of hectares in the swamp area.
Counsel, but as well as the El Nino, there is the climate change issue that, as UNHUR has stated, it is caused by human intervention. How do you reply to this point?
Your Excellency, there is a other interpretation for the human interference. For instance, Rongo considers that human interference is a specific human interference within the area. For instance, if the Rongo's state or Rongo population interfere directly within the area and change the ecological character. However, the changes in the wetland was due to global climate change, was a series of actions combined around the world that Rongo was not completely, doesn't have specifically the duty to communicate to the Ramsar Secretariat, and neither to UNHCR.
Do you have a judgment, a decision of this court supporting your argument?
No, Your Honor, but accordingly to the Ramsar Manual of 2016, third edition, if I'm not mistaken, it is specifically mentioned these two distinction of characteristics of human interference.
What is the legal value of this manual to this court?
And I would add a follow-up question, which would be if this court has ever used, let's say, manuals or any book in its decisions.
Okay, firstly, the value of the manual, it explains the Ramsar Convention item by item, because the Ramsar Conventions, environmental conventions as a whole, are very general, and you can define specific provisions and arguments without the help of the committee that provided that convention, and that's why this court should take into consideration. And also,
was it adopted
38,
in one of the conference of the parties? Because otherwise, it's just literature for us.
Your Honor, I don't have a specific answer to your question. However, still answering your first one, Article 38 of the ICG can take into consideration studies published by high publicists into consideration when applying its decision. And I would ask for Judge Tatiana to repeat your question.
Subsidiary means, Counsel.
Yes,
they are subsidiary. They are, and if you read the full reading of the text, to ascertain the other rules of law, they help to identify the law, but they are not authoritative. They are subsidiary sources.
Yes, Your Honor, and the primary source in that case is the Ramsar Convention, but it's very general to specifically define, so this court should have taken into consideration the second help to specifically address the point in human interference. And Judge Tatiana, if you please repeat your question.
My question was if this court ever used doctrine in its decisions before.
I'm sorry, Your Honor, I don't have the answer to your question, but also based on Article 38, the ICJ can accept books and other provisions to contextualize the decision. Your Excellencies, UNHCR attack on the Manhattan complex, it's neither the result of imperative military necessity, nor it is proportionate. It isn't imperative, for it hasn't been sufficiently demonstrated by UNHCR that there were an urgent need for the said attack, or that there were no other satisfactory strategies. Strategies per se, more proportionate and less harmful to the environment and to Rongo's territory. The information that a proportionality analysis was conducted isn't enough to properly demonstrate that the means chosen for the attack were in fact proportionate. In that sense, even if we consider that UNHCR's proportionality analysis pointed to no excessive destruction, the fact that the said destruction was enforcing does not absolve the warlike state of its duty to take effective precautions against environmental damages. Above all that information, it is important to state that UNHCR's attack violates the UN Charter. Its Article 2.4 strictly prohibits the threat and use of force by its member states. However, states are exceptionally allowed to use force in order to defend themselves if they come under armed attack. Additionally, Article 51 allows states to use force.
Wasn't that the case, Counsel? They suffered an armed attack from your territory. You had a duty of vigilance over that part of the territory that you didn't fulfill.
Your Honor, even after the September 11, the court maintained its understanding that self-defense could only be invoked to an armed attack by one state against another state. And this is found on the advisory opinion of the case of the wall. Therefore, the self-defense...
Well, the wall happened in 2004, and if you read Judge Higgins' opinions, that was a moving law. We have another different situations nowadays that show that there is some practice that says that armed attacks can be conducted by non-state actors. So why isn't that legal? They were solving a problem in your territory.
Your Honor, the understanding of the self-defense against non-private actors, it's understood by the Security Council because of the terrorist acts. However, in that case specifically, Rongo did not ask for a self-defense because Rongo is a third party. And in that sense, although some doctrine considers that Article 51 may authorize the use of force against the non-state actor, it does not extend to the ancillary infringement of sovereignty that UNHUR caused.
But you said that we should take into account doctrine. Why we shouldn't take into account doctrine here, Counsel?
Because in that case, the ICJ has maintained this decision that does not consider the self-defense against no state private actors. And even this doctrine sustains that...
In which case after all? You said that we maintained our position. In which case?
In the paramilitary activities carried out in Nicaragua.
That was before the wall.
I'm sorry then, Your Honor, I don't have the answer to your question. However, I see that my time's come to an end, so I thank this honorable court, and if there is no other questions, I finish my submission. Thank you.
Thank you very much, Agent. So,
rebuttal for the applicant.
right. Will the applicant like to exercise its right to rebuttal?
Yes, Your Excellency.
So please, may begin.
Thank you, Madam President, Your Excellencies. The counsel for the applicant shall address some brief points on the rebuttal as brought by the learned arguments of the respondent. First, that Rongo violated the IAC's provisions. Second, the MPFF's camp was a military objective and therefore cannot be considered as a civilian object. And thirdly, climate change is characterized as human interference. Proceeding to the first topic, the IAC imposes on its Article 4, Paragraph 2C, that to the extent practicable, human activities that could seriously affect sea turtles must be restrained. In this sense, the construction of a tourism destination is not an impracticable measure. On the contrary, UNHUR has to this day protected the area in accordance with international law and found no need to degrade the environment with the construction of hotel complexes. Now, moving on to the second point, civilian objects, according to the ICRC, civilian objects are all objects that are not military objectives. So considering that the MPF's camp was a military objective.
I'm sorry, Counsel, do you have any piece of law rather than an ONG report that sustains your claim?
I'm sorry, if I have
any piece of law, not the ICRC report.
I'm sorry, Your Excellency, I don't. But since the military objective offered a definite military advantage, the attack can be considered a military target, therefore it was not a civilian object. And thirdly, it is important to emphasize that climate change is a consequence of human interference, even if it is not traceable. So even if it is caused by global climate change, it is still human interference, and therefore Rongo should have made the report. Unless I can give any further assistance to this honorable court, this would conclude my submissions. It was an honor to argue before this court today. I shall rest my case. Thank you.
Thank you, Agent. So now we do have those minutes for asking questions.
Yes, so allow me to refresh the rules for both the judges and the participants. At this round, for each team, starting with the applicant, the judges will have 15 minutes to ask you questions. They can ask a specific speaker the question, or they can ask to either of the team. It's up to them. And they can use as much of these 15 minutes or as little as they want. And they don't even have to use those minutes if they feel like they've asked enough questions. The questions can be related to anything from the case or international law. Are there any
15
questions?
minutes for each, right?
Could you please repeat that?
15 minutes for applicant and 15 minutes for respondent, right?
That's correct.
Perfect.
Does anyone have any other questions? Team members, judges?
Yes, I do. Do I trust in English? I think it's okay, right? In the case that the judges specifically ask a question for the team, can me and my co-member answer the question together, or it's just one person per time?
If the judge doesn't specify a member, yes.
Yes,
but if
he doesn't specify a member. Yes. Okay, yeah, that's my question. Thank you.
All right, well, if we're all ready to start, judges, you may start asking questions for the applicant.
Marina, during your presentation, you mentioned a case Guinea-Bissau versus Senegal. Can you remember the score of the facts of that case?
Yes, Your Excellency, I mentioned the arbitral award. So on August of 1989, Guinea-Bissau instituted proceedings against Senegal on the basis of the declarations made by both states under Article 36, paragraph 2 of the statute. And Guinea-Bissau explained that notwithstanding the negotiations pursued from 1977 onwards, these two states had been unable to reach a settlement of a dispute concerning the maritime delimitation to be effected between them. Consequently, they had jointly consent by an arbitration agreement dated by 1985 to submit that dispute to an arbitral tribunal that became the ICJ. Does that answer your question? Thank you.
Yes. Judge Lucas or Judge Marina, do you like to follow, or otherwise I do have another question.
Please go, Madam President.
Marina, again, you in your arguments relied on the Inter-American Court of Human Rights and on the ICRC. Why should we take into consideration such documents in this very court? What are their relevance?
Yes, Your Excellency. According to Article 38D of the statute of this court, the Inter-American Court can be used as a guide since they are written by honorable people, and so they can guide this court throughout its decisions. The ICRC, despite not being a court, they are written from honorable people, and therefore it applies to the same paragraph. They are secondary sources, but still very important to guide this court.
Following up on that question, this court has ever relied on the Inter-American Court of Human Rights before?
Your Excellency, I wouldn't know to answer your question. I'm sorry.
No problem.
And what about other courts, Counsel?
Yes, Your Excellency. This court has already decided has used other courts to its decisions.
Could you give us an example, please?
Yes, Your Excellency. I'm sorry, I don't think I can find it right now. Okay, here, the Myanmar case, they used they used it for the human rights definition.
The Myanmar case that was not decided, the Gambia-Myanmar case.
Yes, that would be the case. But they did use.
Let me ask you another question. Do you think that I would like to discuss more jurisdiction, even if jurisdiction should not be discussed, but I'm not focusing on the jurisdiction to this case. But what about a judgment rendered by 3 judges Was it valid for international law purpose?
Yes, Your Excellency.
Why?
Can you please repeat? Can you please repeat your question?
We are
Just so I
here
can
three
elaborate.
judges, right?
Yes.
We have here three honorable judges. You use the honorable criteria to define the authority of a judge. And I'm asking if the International Court of Justice has powers to render a judgment, having only three judgments, since the full court, three judges, since the full court is composed by 15 judges.
Your Excellency, I don't think I would know how to answer to your question. I'm sorry.
Perhaps your colleague could answer?
If I may, Your Excellency, we do believe this court has the competence to address the merits of this case, seeing that the parties specifically agreed to it in their special agreement. Moreover, this was not this claim of incompetence of the court was not alleged by any of the parties. In this sense, we do reckon that both states are ready to accept and comply with any judgment that may arise from the three judges present here today.
Thank you.
Okay,
Judge Bastos, perhaps.
Yes, I would like to ask regarding the argumentation brought by Rongo that the area has been suffering from drought since 2014. The area where the shooting happened, the bombing happened, and you claim that your action was proportional, and but even if it was proportional, it caused a large fire. So I would like to ask, how can you defend the proportionality of your actions, considering that in the proportionality analysis, apparently the drought and the El Nino and the climate change issue was not taken into consideration?
Sorry, Excellency, do you want me to answer or my colleague? Or
any one of you. Yeah, could be any one of you. It's okay.
Okay, Your Excellency, what the applicant submits is that the proportionality issue was conducted by the commander, but also if we analyze the situation where we have a military group, paramilitary group, out of the reach of the applicant, and it was causing civilian casualties. If you look at the proportionality, the artillery used by UNRWA was not excessive, and it was meant to be just in the area. It was actually just in the area of the MPF's camp. It did not, UNRWA did not bomb any other part of the Manhattan wetland complex. It was only directed at the MPF's camp. So when we analyze it at that way, and furthermore, with the information that UNRWA did not know about the droughts, we can consider its action proportionate.
Yeah, I will insist in this question, because even if you just took action in the place where you're supposed to take action, wouldn't be expectable that the drought, the climate change issue, and the El Nino, and all the things that were happening in the area would cause a fire to happen, considering the bombing is fire, it causes naturally a fire.
Your Excellency, if I may now answer, the UNRWA did this analysis with the information it had at hand, and the drought, of course, global environmental concerns are known by both states parties. However, UNRWA had no way to measure the impact that these droughts had in the Manhattan wetland complex. Without its notification to the Ramsar Secretariat, UNRWA had no way of knowing how much of the area was under these specific conditions of not being able to stop the illustration of a fire. Moreover, Your Excellency, it is stated in the clarification of the facts in answer number 10 that Rango knew that the NPFF was in the manmade wetland complex. In this sense, Your Excellency, the attack could be considered to be imminent. Moreover, there is a criterion to determine the imminence of a attack. In this sense, it is the Caroline formula from 1842, according to which self-defense can only be exercised in the situations where the need to respond is instant. Moreover, Your Excellencies, if we go back to the situation at hand, we will the opinion will prevail that Rango did not take any measures to stop the possible attack. As the Honorable Judge mentioned, Rango had a duty to supervise or be vigilant of the armed activities in its own state. In this sense, by knowing that the NPFF was in the manmade wetland complex and by not notifying the Ramsar Secretariat of any changes in the ecological character of the wetland, and who had no way of knowing the impact that its artillery rounds would have in the area, and had the duty to protect its own citizens in self-defense.
And if I may add, please proceed.
I do have a question upon that. You just mentioned the Caroline formula. Is that preventive or preemptive self-defense?
That is preventive self-defense, Your Excellency. This formula arose from a dispute between Canada and the United States, where the British ambassador proposed that when an attack is imminent, the state that know it will be attacked has the right to self-defense in face of this imminence.
Following up on your argumentation, Kimberly, you mentioned good faith along with your arguments. Is good faith enough to trigger the responsibility of a state?
Your Excellency, the Article 26 of the Vienna Convention mentions both good faith and pacta sunt servanda. They do expressly determine that the obligations must be carried out in good faith. In this sense, the pacta sunt servanda rule is universally recognized and also present in the same article. So even if Rango were to completely disregard good faith, they're still bound to pacta sunt servanda and must comply with the obligations arising from the conventions which they acceded upon.
So, Counsel, why didn't you claim the violation of the Article 26 of the Vienna Convention?
Your Excellency, you mean in the written in the facts or in my pleading?
In your claim, because you used good faith. Why didn't you invoke the violation of Article 26 of Vienna Convention?
Your Excellency, if I'm not mistaken, I did mention that the Vienna Convention of 1969 notes that the principle of good faith and pacta sunt servanda rule are recognized, and that in this sense, as being a signatory of both conventions, Rango must comply with its obligations.
Has this court ever relied upon that in any decision?
I would have to look up on the cases. I do not have any. I do have. In the nuclear test cases, the International Court of Justice proclaimed that one of the basic principles governing the creation and performance of legal obligations, whatever their source, is good faith.
Is that reliance on the terms of Judge Squeff, or is just the statement of the law? The court is using and applying the principle, or just saying this is an important principle?
Your Excellency, if I'm not mistaken, the court has not made an extensive declaration on this principle. I have not found in the specific case if they do define the term good faith, meaning or declaring its meaning or how it will be applicable. I do, however, claim that the International Court of Justice has previously used good faith as one of the basic principles of international law, and therefore binding upon the states, which acceded to the ICJ statute.
Okay, I have one last question, but I would like to ask if Judge Bastos would like to use the time, the last minute. My question is, why didn't you rely more in the law of state responsibility to claim your case and to invoke the responsibility of the other party? Do you think that the law of state responsibility would help or would go against your claims, counsel?
Your Excellency, what we do present at this time, there is no definitive result of sovereignty. If Rongo is determined to be the sovereign country of Kempke, then of course it will be a different state responsibility. So at this time, we cannot claim to be victims of certain transboundary harm. And in this sense, as they're still in the open, these questions, we preferred to take another route than the state responsibility claims.
Now, if I may use the last seconds to finish answering Marina's question about El Niño. El Niño is not only happens in the Pacific Ocean, and there's nothing that mentions in the facts that Anhur and Rongo stays in the Pacific. So I'm sorry, my time is up.
Thank you very much. Okay, so now let's begin with the questions for the respondent. I don't know if Judge Lima, Judge Bastos. Oh, did you?
You have to wait the
time, right?
Yeah.
Judge Lima or Judge Bastos, would you like to start?
Oh, I can start then. My first question would be regarding the tourist complex. Do you understand that the shade screens and window tinting that you suggest that would address the issue of the turtles would be enough to mitigate all the impacts in the tourist area?
Your Excellency, considering what came up in the EIA, and it was only the lighting situation in areas facing the beach, the respondent submits that for now, based on this particular EIA in this point in time, the shading of the screens and tinted windows would be enough to mitigate this harm. However, we do highlight that in other areas where it has to be lit up for safety purposes, there are certain colors of lighting, such as amber or red lighting, that are known to be turtle safe and that is based on scientific evidence of the Sea Turtle Conservancy.
Following up on this question, thinking about the project itself, Rongo is trying to build a tourist complex in a very sensitive, environmental sensitive area. And according to, as you claim, the sustainable principle, the sustainable development principle, you have to emphasize not only the environmental, the economic and social issues, but also the environmental ones. And sometimes it means to cancel projects or to reallocate projects to another areas. And how do you understand that the decision to go to follow on with the project is a decision that is most consistent with the principle of sustainable development? Wouldn't it be better to try to do something else in another place, perhaps?
Your Excellency, that is a great point. However, we highlight first that this cute coastal wetland had been facing inappropriate agricultural practices, subsistence hunting, and other kinds of exploitation when it was under Anhur's administration. And for that, and with that in mind, Rongo wants to highlight this area by giving it the attention it deserves. With increased attention brought in by this hotel, not only will it increase public participation in environmental activities, but also government and non-governmental institutions. Now, for the question of whether we could have used another area to build this hotel complex project, we highlight that the majority of the Kempke population is ethnically Rongoan, and speak Rongoan. So the government wants to protect and support their own ethnic population by creating this hotel complex. Therefore, balancing not only the social economics, the local empowerment, but also the environmental protection by giving attention to a wetland that was otherwise neglected.
But Gabriela, it seems to me that, for instance, when it comes to the application of sustainable development, and you mentioned a lot of times that your state is a developing state, both states here are developing states. Therefore, shouldn't we take into consideration the construction of the hotel and also the no harm principle when it comes to its construction?
Yes, Your Excellency, we definitely should take into consideration the no harm principle. However, given that the EIA only showed up the lighting situation and we are applying mitigation measures to that, there is no indication that transboundary harm would even happen in this case. And to highlight, to draw a parallel, I like to highlight the case of construction of a road along the San Juan River, where the court found that Nicaragua failed to prove that the project of Costa Rica along the construction of the road was likely to cause transboundary harm. Therefore, it rejected its claim. In this case, it's a similar situation, and HUR has yet to prove that Rongo's actions would constitute transboundary harm.
But then wouldn't you be
I'm sorry.
Just a quick follow-up. Wouldn't you be contradicting yourself when you said during your arguments that we could apply both precaution and prevention? Because it seems to me that the court there did not use the precautionary principle. So could you enlighten or elaborate on the difference between both?
Yes, Your Excellency, the precautionary principle states that despite scientific advances, more protection to the environment must be awarded if there is any kind of scientific evidence that there is harm to happen. However, this court has been skeptical about the application of the precautionary principle. However, the prevention principle, which is the one that we see most explicitly in this case, states that it's up to states to prevent potential harm by conducting impact assessments and mitigating potential risks that come up on those environmental impact assessments.
My question goes in that direction. Why the court is not allowed to make a reverse of the burden of proof in this case? Since you meant part of your argument is not yet. Why the court is not able to make a reversal of the burden of proof?
Your Excellency, as a general rule, the burden of proof lies with the claimant. And once there is no indication that Rongo did not comply with all of the requirements for the EIA, the respondent does not see any reason why the burden of proof would be inverted.
Okay, I have another question to you.
Could the court invert?
The court could invert the burden of proof, as stated in the Croatian genocide case, where it stated that in some cases, depending on a case-by-case basis, the court could invert the burden of proof. However, in that case, in the Croatian genocide case, it was decided ultimately that Croatia was the one who bore the burden of proof.
Okay, let me ask a question to you, Gabriela, and then I have another question to Caroline. You are defending the construction on a territory that's not proven yours yet. Why is it illegitimate, the use of force made by the applicant, but you that took over an island, is it legitimate to use the force? Could you explain why in that case there is an illegitimate use of force, and in your case is a lawful addition of the territory?
Your Excellency, in that case, the use of force by UNHUR created immense destruction to the Menhit wetland complex, which is not only important to Rongo, but also to the global community as a whole once wetlands
You are
are
qualifying the acquisition of the territory by the victims and the damage, but still you acquired a territory by the use of force. Why is it legitimate in this case?
in our case, Your Excellencies, Rongo conducted a referendum which came up that 90% of the population would want to be a part of Rongo. Also, this population is mostly
before the invasion
after
or
the occupation.
After the occupation. So it served only to legitimize our already established status, right? So I would like to have the legal answer. Perhaps Caroline would like to join you in that. The legal foundation why your use of force is legitimate and is according to the UN Charter.
Your Excellency, there is a provision in international law that states the self-determination of peoples, and the respondent does believe it applies to this case once the population is mostly ethnically Rongoan. Therefore, it must determine which state they want to be a part of. In this case, it was Rongo.
This provision region is not in the UN Charter.
It's not in the UN Charter. However, the court applied this provision in the construction of a wall on occupied Palestinian territory, the ICJ case.
Any other case of ICJ where the self-determination was applied?
Your Excellencies, I could not give you another one right now. However, in the wall case, it was definitely applied.
Your Honor, I'm sorry, I didn't understand you say if I could add to the, yes?
Yes, please,
okay.
join.
I would like to also state that, as stated in the record, the IEMCC as Rongo territory was internationally recognized by the states that makes part of the UN, and also a case in which the determination of states was recognized. It was in the advisory opinion of the ICJ related to Kosovo independence.
Yeah, but that opinion does not help you because the courts did not use this criteria to determine if the independence was lawful on the basis of recognition.
Yes, the point in that advisory opinion was about if violated or not international law, sorry. However, in that advisory opinion, it was severally stated the self-determination of people, the principle.
Okay, and you have an explanation why the occupation, to use the words that your co-agent used, was the occupation did not violate the use of force, Article 51 and 2.4 of the UN Charter?
No, Your Honor, because the occupation did not use armed attack or armed forces in the area of IEMCC.
So is it legitimate? You can just enter a territory of a state with your army, and if there's no resistance, it's yours. That's your claim, counsel.
I did not say that it was legitimate. I said that it was not breach. Rongo did not breach the UN Charter of Article 51 when act in the behavior of your own people, as the IEMCC is is the most majority part is Rongoan people in that area.
Caroline, I do have a question for you. Judge Lucas asked you about clean hands during your argumentation, but you didn't answer to that part. Do you know what's the principle of clean hands? And does your state have clean hands to appear before this court?
Your Honor, if I am mistaken, you can correct me, but the principle of clean hands states that I will exemplify in this matter that Rongo did not think that the construction of the hotel project will have any harm or violate international law. And no, because as stated in our EIA, there is no risk of transboundary harm. And the national legislation that is used in the EIA was recognized in the Pulp Mills case. Therefore, we are complying with international preventions. And also, Rongo would have the duty to notify and consult only if there were a transboundary harm, and the EIA showed that there is no risk of that. Therefore, yes, we are with clean hands at the case, because our hotel project will help the impoverishment community and also help to protect the wetlands as it was facing agricultural practices, marine exploitation. The area was not fulfilling the purposes of the Ramsar Convention, and is Rongo is going to fulfill that obligations in the construction of the hotel project.
I'm not sure if Judge Bastos has a question. I have a last one if Judge Lucas does not have. In your argumentation, Caroline, you also mentioned the protection of civilians. Which Geneva Convention protects civilians?
The protection of the civilians is in the Geneva Conventions of 1949. Is stated the protection of wounded civilians, and also this specific provision of civilian in character is in military objects is in Article 51 of the additional protocol. However, Rongo, it's not part of the additional protocol, as stated in the case the prosecutor versus the Pavlov. This principle of military objective is considered customary law. Therefore, it applies to the case at hand.
Your Excellency, if I may add to my co-agent's answer, just really quick. My time is up.
Yes.
5 seconds.
The Geneva Convention number 4, relates to the protection of civilians.
Thank you, Gabriela.
Thank you.
I think the time now is up. So thank you both agents for the applicant and the respondent. I give back now the floor to Mr. Melo so he can conduct our
Thank you, everyone. The session is now officially adjourned. I will now take judges to a separate room to deliberate on the matter, and we'll be back soon with the results. Judges, you will see an invitation pop up on your screens in 1, 2, 3. There you go.
Olá, pessoal. Podem ligar suas câmeras. Nós vamos aqui fazer uma breve apresentação dos juízes, feedback, mas o resultado sai logo após na sala de encerramento do Zoom. O link já está no WhatsApp, então, uma vez encerrado aqui, todo mundo segue lá para o Zoom do encerramento. Vou deixar aqui que a professora Tatiana comece.
Faço em inglês, faço em português? Rui, já fiquei na dúvida agora.
À vontade. Agora, nós estamos de volta ao Brasil, já saímos da consideração de justiça.
Perfeito. Então, boa noite, meninas. Foi um prazer imenso participar aqui dessa rodada final. Acho que isso a gente pode, nos foi autorizado a dizer, nós tivemos um split bench aqui na decisão, então não foi uma decisão unânime, porque estava muito boa essa final, um altíssimo nível nos argumentos. Eu fiquei muito honrada de estar aqui, de ouvi-las na noite de hoje. Alguns pequenos assim, feedbacks, que eu acredito que é o que vocês querem ouvir justamente para melhorar, para improve, para uma nova etapa, uma nova competição. Então, diria para vocês que gostei da cordialidade de vocês para com os juízes. Eu acho sempre importante essa presteza na atenção nas perguntas que são feitas, mas mais do que isso, eu acredito que em alguns momentos, talvez tentem ser um pouquinho... Eu sei que a gente quer ouvir sim ou não quando é sim ou não, mas às vezes, até para aquilo que é bom para vocês, dizer um well né, e se encaminhar para uma resposta, na minha visão, por vezes é até interessante, na medida em que, se você dizer sim ou não, talvez isso prejudique sobremaneira, né, o argumento que vocês estão trazendo. Em relação a uma questão só que eu pensei, dos casos da CIG prévios, né? Então, tomem as perguntas aqui que fizemos para vocês como base para buscar casos na CIG, para abastecer a jurisprudência de vocês, porque isso é bastante importante, saber outros casos, talvez que tenham debatido alguns pontos de argumentos secundários que vocês tenham, talvez isso seja bastante significativo para para uma rodada internacional ou para um próximo ano, na tentativa de sempre melhorar. E façam um banquinho de jurisprudência, vocês já vão salvando o que é o caso, quais são os principais pontos, isso também depois fica para a posteridade, para a universidade, para os grupos ainda que virão para próximas edições. No mais, eu acredito que sejam esses os meus feedbacks, para não ser muito prolongada aqui a minha exposição. Eu, enfim, não me apresentei, né? Eu sou a Tatiana, sou professora da Federal de Uberlândia, de Direito Internacional, da graduação e do mestrado. Um prazer imenso aqui trabalhar com vocês, porque no mestrado a gente trabalha com a área de Direito Ambiental Internacional, então eu fico muito contente em vê-las debatendo Direito Ambiental Internacional aqui de uma maneira tão aprofundada e trazendo diversos aspectos que tocam a temática do Direito Ambiental Internacional, não apenas em tempos de paz, como também de conflito armado. Então, prazer imenso. Passo a palavra agora para a professora Marina, para que ela possa também fazer as suas considerações.
Obrigada, Tatiana. Eu também aqui fazendo minha apresentação, eu sou uma novata nessa área de multi, então eu aprendi muito com vocês, estou aprendendo ainda bastante como funciona um multi, é muito interessante mesmo, e eu fiquei encantada com a argumentação de vocês, eu achei que vocês estavam extremamente bem preparadas, e eu realmente teria pouquíssimas notas a trazer, exceto acho que um único ponto que eu acho que é um ponto que vai ser endereçado até um potencial trabalho aí mais para frente para vocês, que é o ponto do preparo mesmo, né? Do tipo, tentar evitar um pouco leituras quando você está falando alguma coisa, tentar ter um pouco as coisas em mente, assim, quando vocês estão trazendo um argumento, enfim, mas isso é uma questão de preparo e também de experiência e relaxamento, né, do tipo de você tentar superar esse nervosismo que é, às vezes, muito difícil. A gente tem aqui, eu tenho mais de 10 anos de carreira e às vezes me bate um nervoso, dou uma gaguejada, então faz parte, gente, não se martirizem por isso, mas assim, é mais, isso vem com o tempo, com o preparo e com muito estudo, então eu tenho certeza que vocês estudaram bastante, porque eu vi como vocês estavam preparadas, mas é isso, é continuar, é um esforço eterno e infelizmente é um negócio que não acaba nunca, a gente tem que estudar assim sempre, mas vocês estão muito de parabéns enfim, aprendi muito com vocês, muito obrigada. E também, só falar de mim também, que nem a Tatiana, esqueci de falar, eu sou professora em Direito Ambiental, eu estou concluindo meu doutorado em Direito Ambiental na USP, e, enfim, eu não tenho um foco muito grande em direito internacional, então até como vocês perceberam, minhas perguntas eram mais focadas em ambiental, mas enfim, gosto muito da área e achei interessantíssimo, queria agradecer.
Posso? Próximo, Madame Presidente. Boa noite, meninas. Meu nome é Lucas Lima, eu sou professor de Direito Internacional e Direito Internacional Ambiental na UFMG. Tenho o prazer de acompanhar a Stetson há muito tempo. O Rui, foi a primeira vez que eu tive contato com a Stetson. O Rui, eu tive a oportunidade de julgar o Rui. Eu gosto muito dessa competição. Eu gosto muito dessa competição porque ela é um pouco diferente de outras competições e ela permite que a gente conheça uma série de pessoas de áreas interdisciplinares. A professora Tatiana já conheci há algum tempo, hoje tive o prazer de conhecer a professora Marina, e vocês hoje conheceram a nós, os contatos continuam, essas competições, no fim das contas, não são sobre ganhar ou perder, mas sim de se divertir no processo, fazer um bom trabalho, aprender direito internacional, aprender a escrever inglês, é sobre fair play, é sobre saber entender do outro lado, não ver o outro lado como inimigo, é um pouco não levar ressentimentos para a vida. Quem faz isso faz mal essas competições. Vocês, no fim das contas, conquistaram muito chegando aqui hoje nessa final. Nós, posso revelar isso, demoramos para saber quem era efetivamente a campeã, porque os níveis estão altíssimos, e para nós foi muito difícil tomar essa decisão. Então, mas não entendam, se você não foi o principal, não entendam essa decisão como não fui. Simplesmente precisávamos escolher alguém. Foi muito bom. Eu confesso, sinceramente, eu tive um caso, uma vez na Corte Internacional de Justiça, e o que eu vi hoje aqui de vocês foi muito similar a algumas das plaideries de Alain Pelé ou esqueci o nome da Lochon de Chazur, na frente da Corte. Então, parabéns a vocês. Meus dois conselhos para as próximas etapas, já que uma de vocês, uma das equipes, vai à Flórida. O trabalho não acabou, o direito tem que ser melhor explorado em alguns casos. A gente indicou onde estava faltando nas nossas perguntas, eu acho que vai ficar o vídeo, depois olhem. Por exemplo, responsabilidade internacional não foi explorado por vocês, é típico dessas competições que responsabilidade internacional entre. Então, eventualmente, tenham em conta isso, olhem outros branches do direito internacional para vocês se fortalecerem, sobretudo nessas respostas. Procedimento é algo que também é importante, vocês têm que conhecer a corte, como ela age, o que ela usa, o que ela não usa. Isso, efetivamente, como diz a professora Tatiana Squeff, é algo que vocês vão adquirir lendo sentenças, se preparando, enfim, estando atualizadas. Eu acho que é um pouco isso, essa competição. Eu deixo aqui para vocês os meus parabéns. Repito, a partir de hoje vocês têm a minha amizade e foi um prazer. Eu posso ser muito chato durante o bench, mas a professora Tatiana pode confirmar que eu também sou chato fora do bench. Então, vocês saem daqui minhas amigas. Quando vierem ao FMG, me escrevam. Tem Instagram, hoje em dia a gente faz esse contato facilmente. É um prazer e obrigado mais uma vez ao Instituto pelo convite. Para mim foi uma honra e está uma honra ao lado dessas duas excelentes professoras. Obrigado, Rui.
Obrigado, Lucas. Bem, de início, eu agradeço a todos os convidados aqui, Tatiana, Marina, Lucas, por terem aceitado o convite e terem se dedicado a aprender esse caso e fazer perguntas muito interessantes. Uma coisa que eu destacaria sobre o Lucas, que vocês descobriram na prática, se não já tinham assistido a rodada do ano passado, é que ele tem umas perguntas que são surpresas, são perguntas que fogem do padrão, que ele já vai do início para poder ver se você tem jogo de cintura, né? E eu vou dizer, Lucas, o pessoal que competiu lá naquela época tava tudo no WhatsApp aqui, comentando as suas perguntas. Desde a clássica pergunta dos 3 juízes, para a pergunta do... Todas as perguntas que você fez, fugindo do padrão.
Do council e do agent.
Council,
Essa eu digo
Essa
para
também é
vocês que ele
clássica.
faz em várias competições, né, seu Lucas?
Exatamente,
Tem vídeos
exatamente.
dele para essa resposta, inclusive.
Mas esse ano eu
Procurem no
trouxe uma
YouTube.
nova. Esse ano eu trouxe uma nova que era, eu acho que tem um probleminha naquele special agreement que os estados escreveram. Mas, enfim, eu queria ver se alguém mais tinha notado. Era mais uma curiosidade minha.
Pois então, pessoal, muito obrigado por toda a participação. A equipe estão de muito parabéns. Então, vamos encerrar aqui a rodada. Obrigado pela participação. E daqui a pouquinho a equipe já pode entrar no link do Zoom da cerimônia de encerramento. Vamos tirar uma foto, na verdade, antes que terminemos aqui e a gente esqueça disso. Então, vamos lá. Todo mundo sorria virtualmente. Em 3, 2, 1. Perfeito, pessoal. Então, obrigado, juízes. Obrigado, equipes. Até já.